I am going to explain these 10 provisions as they relate to contract law. A common characteristic of these provisions is that they are ways that a party can reduce their risk in a contract. I will provide a summary of these provisions near the end of this video. A lot of these provisions are common in music contracts, so I believe it is important that musicians understand them. A lot of the information in this video applies to other types of contracts as well. A bilateral contract is an exchange of promises that is enforceable by law. One party promises ABC in exchange for another party promising XYZ. I made another video that further explained what a contract is. A contract may carry a certain amount of risk for each party. If one of the parties fails to fulfill one of their promises, or if they fulfill it poorly, or if a negative event related to the contract occurs that neither party foresaw, it may cause economic or physical harm to someone, and one or both parties to the contract might be liable for that harm. So to reduce their own risk in a contract, a party might try to include one or more of the provisions listed earlier. A representation is a statement of fact made to induce someone to enter into a contract. Representations may only be made about the past or present, not the future. A warranty states that something related to the contract is guaranteed by one of the parties. Warranties may only be made about the present or future, not the past. The terms warranty and representation are often used interchangeably, and in some cases together in the same statement. However, a warranty technically differs from a representation in that it implies that the person making the warranty will compensate the other party should that warranty turn out to be false. In some cases, a misrepresentation might cause a court to allow rescission, the cancellation of a contract. A breach of warranty might require compensation, but is less likely to result in rescission. A covenant is a promise to do or refrain from doing an action. A covenant is more formal than a typical promise made in a contract and is often formatted as party covenants to X. How does a covenant differ from a warranty? A warranty is essentially an implied promise to compensate a party if the statement turns out to be false. However, if the statement turns out to be true, there would be no compensation. So in a vacuum, a warranty is a conditional promise to do an action. A covenant would have no such condition. In a vacuum, it is simply an unconditional promise to do or refrain from doing an action. An indemnity is an obligation to compensate a party for their losses or damages. In a music contract, a company might try to include an indemnity provision that requires the musician to compensate the company if the company suffers a loss due to certain types of acts, omissions, or occurrences defined in the contract. I have read music contracts where the indemnity provisions were very lopsided against the musician, so it is important for musicians seeking to sign music contracts to understand indemnity. In my opinion, if an excessive indemnity clause is not negotiated away completely, a musician should seek to limit the scope of causes that would trigger an indemnity to things that the musician has control over, such as one of the representations being false. Limitation of liability provisions reduce the liability of a party in one or more of the following ways: limiting the type of losses that a party is liable for, limiting the types of remedies available in the event of a breach of contract, limiting the amount of damages payable in the event of a breach of contract, or limiting the time frame that a party has to sue for damages. Rather than just limit a party's liability for loss or harm caused in specific situations, a hold harmless provision seeks to completely remove a party's liability in such situations. A duty to defend is an obligation to defend or fund the defense of a claim made against another party. If present, duty to defend clauses are often used in conjunction with indemnification clauses. If the defending party is obligated to both put together and fund the defense, then the defended party may have the right to approve of the legal counsel and legal strategy. If the defending party is only obligated to fund the defense but not put it together, then they might not have any control over the legal counsel and legal strategy chosen by the defended party. Paying for something that you have no control over is not a good position to be in, so it'd be in the defending party's interest to negotiate some control over these things, as well as negotiate a cap on the legal costs they would have to pay for. Subrogation is when one party takes the place of another in relation to a debt, claim, or right. Subrogation is common in insurance. For example, if Jack causes his car to drive into Jill's car and both are insured, then Jack's insurance should pay for Jill's car repairs and medical expenses. However, if Jack and his insurance company are disputing his fault, then those payments might be delayed, in which case Jill's insurance company would step in and pay her bills. Now, Jill's insurance company wants to be reimbursed for the money they paid that Jack's insurance company should have paid. Technically, Jack's insurance company owes money to Jill, but a right of subrogation would give Jill's insurance company the right to take her place and pursue and receive that money themselves. If Party A has access to a superior legal team and also has an obligation to indemnify Party B for a loss, then a right of subrogation could reduce Party A's risk by allowing it to take the place of Party B, who might otherwise have a higher chance of losing a case that would ultimately cost Party A money. A waiver of subrogation is when one party agrees to not exercise their right to subrogation. If Party A has a right of subrogation over Party B's claims, then a waiver of subrogation would allow Party B to waive Party A's right. This might be beneficial for Party B if they wish to settle a case out of court or otherwise avoid a lawsuit being brought against the party they have a claim with. Arbitration is a dispute resolution method that is an alternative to going to court. Typically, both parties will agree on a neutral third-party arbitrator to hear the case and issue a legally binding decision. Resolving a dispute via arbitration is not necessarily a problem. Both parties might find the arbitration process preferable to court, as it is generally cheaper and faster. However, if a contract requires arbitration rather than leaving it voluntary, it may reduce the risk of the party that has more money. Arbitration is generally private and confidential. This may benefit a music company much more than a musician. A musician might have less leverage if they do not have a legal right to speak publicly about an issue, and if there is limited news coverage because the proceedings are not public. There are a lot of people in the music business that lack integrity, and they might be more inclined to treat a musician poorly if they believe a musician is unlikely to hold them publicly accountable. Arbitration may also have a more limited and strict discovery compared to court, which may make it more difficult for each side to request a lot of documents and witness depositions. Arbitration might award more limited remedies to the winner compared to what a court would award, and options to appeal an arbitration decision are typically much more limited or non-existent versus appealing a court decision. If a musician is contemplating entering into a music contract, it is important they note how much risk they will be assuming in doing so. If they have less bargaining power than the other party, then that other party might attempt to have the musician assume an inordinate amount of risk. If so, it's up to the musician and their advisors to decide whether to accept it, try to negotiate it away, try to negotiate something in return, or walk away. Also, if one party has significantly more negotiating power than another party, they should also be careful not to go overboard with risk management clauses in their own favor. Otherwise, a court might view the agreement as unconscionable and thus unenforceable by law. Contract law can vary significantly by jurisdiction, so it is recommended to consult with an experienced attorney when negotiating a contract. Here is a summary of these risk management methods.